Hear ye, hear ye. The Colorado Court of Appeals is now in session. Please be seated.
Good afternoon. Welcome to Division 5 of the Court of Appeals. We have one case remaining on our docket for this afternoon, People in the Interest of HT. I assume council have had an opportunity to look at our procedures. Do you have any questions about those?
No questions, John.
Okay. I just want to remind you of a few things. First, there's a toggle switch on the podium here that allows it to go up and down, if you would like to use that. Also, I would ask anybody in the room, if you have any cell phones or similar devices, to please turn those off during the arguments this afternoon. Counsel for the appellant, you may try to reserve some time for rebuttal, but of course that's going to depend on how the questioning goes. I also note that this case involves children who are referred to by initials, so I just want to remind counsel that let's keep referring to them by initials and not by their names. I know sometimes that's difficult to remember, but it's important. So if there aren't any further questions, we're ready to proceed.
May it please the court, Arthur Spiciotti, Assistant Larimer County Attorney, Attorney Registration Number 41571, representing the people of the state of Colorado. Opposing counsel. Your Honors, what is a dependency and neglect case? Dependency and neglect case is a lawsuit defined by the rules of juvenile procedure as civil in nature that alleges that the parents, well, it's alleged on behalf of the child, but the parents have failed to fulfill their obligations under the contract, the family contract of being a parent. With that understanding and that perspective on this, on DNNs in general, I believe that sets the tone for how the questions before the court today can be addressed. There's two questions. There's the procedural question that the court has raised and the substantive question that the people have raised. I begin with the procedural question of finality. It's a confusing situation. The status of appealable orders that give this court jurisdiction. There's much case law, yet nothing specific to this certain type of case. And in reviewing the record, this is a very long and confusing matter. The dispositional order is a final appealable order by definition in the statute. 19.1.109 specifically defines termination orders and adjudication orders after disposition as appealable final orders to coincide with Title 13's requirement that there be a final order for this court to have jurisdiction to review. There may be a question about, is the disposition itself appealable? It would be illogical to read 19.1.109 and the specific language the legislature chose about an adjudication and a disposition to say that they meant that only the adjudication could be appealed and not the disposition. So for that reason, this case by definition is appealable. But moreover, the dependency and neglect case, as I talked about at my beginning, is essentially a family law case, determining the rights and responsibilities in a family law, in a family. Those rights change from day to day. Those responsibilities change from day to day. And every order entered in a family law case that addresses those rights and responsibilities is a final order for that moment in time.
Counsel, that's a little troubling because where you're going with that means that we would allow appeals from all of those orders. That would open the floodgates. I don't think that's what the legislature intended. Do you?
It's a fair point, Your Honor. The question in DNN cases is not will all of these potentially be allowable to be appealed, but in the time constraints of an EPP case such as this one, will there be time to appeal these orders? These orders will become moot, and appeals will become moot almost weekly, monthly as cases progress. So as an application, I would respond to your question, Judge, that it just wouldn't in reality play out that way.
But doesn't the very fact that they would repeatedly become moot because they keep getting changed indicate that the legislature wouldn't have intended to have appeals of those orders because of the immense waste of time and resources? Appeal, mootness, appeal the next order, mootness, et cetera.
The question could be larger, and did the Court of Appeal, or did the legislature address what is appealable from a DNN other than those two things? Because essentially, either nothing is appealable from a DNN case, or everything that addresses those rights and responsibilities is appealable from in a DNN case. And in fact, the legislature went back in the 90s and specifically said a termination order is final. Logically, that seems obvious, but they had to clarify that you could either see nothing being final or everything being final, and people could argue that nothing was final. And ultimately, a termination order isn't final. It doesn't address all of the rights of the child at that time. Just because a interim custody order is entered in a DNN case doesn't, and that interim order could be addressed again and refined or revised again. Custody could change from mom to dad to the grandparent. It doesn't mean that that order for that moment for that family isn't final. And there's no statute that specifically says that addresses what is not a final order.
Well, but you would concede, counsel, that if each one of those was appealable, it could it really slow down the process of determining what the outcome is in any given DNN case, right? Appeals take time.
It's recognizable that that could happen. That
As it has in this case. It's slowed down the progress of this case, I assume.
Your Honor, I would argue that the record doesn't necessarily show that one way or the other, what's going on with this case as it stands right now in the trial court. And that's the unique nature of, that touches exactly on my points, the unique nature of a family law case and a DNN case. These families' lives have moved on day to day ever since last summer when the first order was entered.
But there's been no final ruling on the termination because the treatment plan hasn't been complied with, right?
Well, that supposes that there's been a termination requested.
Okay. I understand that piece, but
So I don't know that the cases have to move forward. Your Honor, everyone's lives will move forward. The child's life will move forward. The respondent father's life will move forward. They have to move forward towards permanency one way or the other. And if the courts, as noted in Appellee GAL's response brief, the statutes specifically allow the trial courts to continue to make dispositional orders while an appeal is pending. So the legislature maybe did envision that this would be going on, and orders may become moot before they become appealed, or they become determined by the Court of Appeals.
Counsel, I'm just looking at the language of the statute.
Yes, sir.
The first sentence says, an order decreeing a child to be neglected or dependent shall be final and appealable after the entry of the disposition pursuant to section 19-3-508. So that says that an order decreeing a child to be neglected or dependent is final and appealable, but it doesn't say the dispositional order itself is final and appealable. It simply uses that order as a trigger for finality of the order decreeing a child to be neglected or dependent.
The people's argument, Your Honor, is that the reading of statutory construction would be illogical to say that the legislature wanted you to be able to appeal essentially the finding of guilt, but not the sentence.
But you haven't appealed the finding of guilt, as you put it. I mean, perhaps, maybe, I don't know, this, it's not this case, perhaps you can appeal the dispositional order if you're appealing the order decreeing a child to be neglected or dependent, but you haven't done that, neither has anybody else.
But that, Your Honor, I point to my brief, I cite to People v. GS, Supreme Court case from last year. And the Supreme Court in GS talks about how the language that you just read is expansive. It expands the definition of final order. It doesn't confine the definition of final order. That doesn't mean that there aren't many other types of final orders in a DNN case that will be final for some other reason other than that they were defined final by the legislature in 191109. Turning to the substantive matter, and this plays together with the finality, the question of why this order should be reviewed regardless. The Department of Human Services is not a party to the dependency and neglect case. And there's no other recourse for them than to have an opportunity, the people to file this appeal and address this with the court.
Didn't the department file the petition?
No, the people of the state of Colorado filed a petition. The caption says the people of the state of Colorado. The department filed a report with the court that was the basis for the facts that support the petition. The people file in the interest of the child. The child is essentially suing their parent for lack of proper parenting, and they're incompetent to do so. So the state stands in their stead.
So the department had nothing to do with the petition being filed?
The department wrote a report to the court, and that formed the basis for the petition that the county attorney signed.
So if you're right about that, that the DSS is not a party to the case, how can they appeal?
They're not appealing. The people are appealing.
Okay,
How do the people have standing to assert that on behalf of the department then?
The people are a party to the case, and the people have the right to appeal any order in the case.
But the people, their money's not at stake. They're not being ordered to do anything. It's the department, right?
It's a case that we're prosecuting. We have a right to get proper determinations within the case that we're prosecuting.
Counsel, you said you don't have any remedy. Why don't you have a remedy under Rule 21 of the appellate rules? Because in essence, your argument on the substance is that the trial court is doing something that violates separation of powers or something to that effect. Why wouldn't that fall under Rule 21, where you file your petition with the Supreme Court claiming that the trial court is exceeding its jurisdiction?
You know, that's a possible remedy, one that hasn't been considered in this matter. I don't have any further thoughts on that. With that, I ask to reserve the remainder of my time for rebuttal. Thank you.
Thank you, counsel. Thank you, counsel. You may proceed.
May it please the court. My name is Chelsea Carr, attorney registration 48961, and I represent appellee respondent father. This case is determined by two issues. First, the order appealed in this case is not a final appealable order. And second, even if the order is appealable, the lower court's findings here are supported by the record. At the outset of this case, my client was under a criminal investigation in South Carolina. However, the detective in charge of that case determined that they would not be filing any charges against my client. The department wanted to have my client undertake SOMB treatment, however, so they made it a condition of his deferred adjudication. My client could not afford to make those payments for that treatment. So he filed a motion for objecting to the treatment and requesting that the government pay for it. The court ultimately entered a ruling on that, an oral ruling requiring that the government either pay for the treatment or remove it from the treatment plan to allow my client a chance to succeed. The parties then entered into a stipulated adjudication where they agreed that my client would undertake the treatment and that the government would pay for it. The court entered its adjudication order and a separate dispositional order. The dispositional order noted the parties' stipulation and adopted the treatment plan, but did not mention what was included in the treatment plan or who would pay for it. A few weeks later, the government filed a motion for a written order on the court's previous oral ruling. And on August 9th, 2018, the lower court entered that order. This is the order from which the government appeals, and that order is not a final appealable order. Pursuant to CRS 19.1.109 subsection 1, parties may take an appeal as provided in CRS 13.4.102 from any order, decree, or judgment. However, 13.4.102 specifies that this must be from any final judgment. And the case law sets forth that it's clear that this is a judgment which ends the particular action in which it is entered, leaving nothing further for the court to do. Opposing counsel noted the unique nature of dependency and neglect cases. Here, this case is far from final. Although we have an adjudication, the parties continue to appear before the trial court. They continue to be able to file motions, and they continue to be able to request the court to change the treatment plan as it sees fit.
So if this ruling had gone against your client and the court had said, no, I don't think the department should have to pay for it, would you concede that your client wouldn't be able to appeal that as an interlocutory matter either?
As I read the statute, Your Honor, this would not qualify as one of those specific exceptions that are listed in 19.1.109 subsection 2. It wouldn't be a final order, and if the court had said such a thing in its adjudication, my client would be able to appeal. However, that's not the case here. So had the court ruled against my client in this instance on a separate motion outside of that adjudication order, I would agree with you, Your Honor, that this would not be appealable by my client either. Pursuant to CRS 19.1.109 subsection 2, there are 3 different exceptions to the finality rule. When there's a question of law in a delinquency case, termination or an order denying termination, or adjudication after the disposition order enters. Here, there's no question that this is not a delinquency case, and there's no question that this is not a termination order or the denial of a termination order. The government argues that it's part of the dispositional order. However, in this case, this was a separate order on a separate motion that was heard in a separate hearing. It was removed several months in time from the actual adjudication. In February of 2018, the court had a hearing to address my client's motion. And the court actually withheld its ruling because the government wanted to be able to contact the county and determine whether the county would make this payment voluntarily. If the court had issued its order on the date of the hearing, again, months before the actual adjudication entered, there would be no question at this point in time. It's only because the government requested that that ruling be withheld that the timeframes ended up being shrunk later on. Furthermore, when the government filed its request for a written order on June 27th of 2018, they did not mention a dispositional order, they did not mention a supplement to that order, or even an amendment to that order. The government just asked that the court reduce its prior oral ruling into writing. And that oral ruling was not a part of the dispositional order. But even if the government is correct in asserting that this is part of the dispositional order, because it's not an adjudication order, it still does not qualify. So, as the court noted with opposing counsel, here, the statute is specific in that it states that it's the order decreeing a child to be neglected or dependent shall be appealable, but only after that dispositional order enters. A lot of the court's concerns that I heard were about what are the scope of the potential, what appeals could be opened up. And I agree that that would increase the possibility of there being a significant number if all dispositional orders, all changes to the treatment plan can then be appealed. I personally and my client, we do not believe that that is what was intended by the statute. Here, the language of the statute is clear. It says an order decreeing the child to be neglected or dependent. It doesn't say an order specifically adopting the treatment plan.
Counsel, can you respond to your opponent's argument that in GS, the Supreme Court characterized 19.1.1092C and that language as actually expanding what and not placing a limit on what can be appealed? So
opposing counsel and I cite this case slightly differently. We cite it as people in interest of RS. So you will see both of those citations in our briefs, and it's actually to the same case. And we believe that that language actually is specifying that only certain orders can be appealed. And the reason why I would say that, Your Honor, is because people in interest of RS actually, what it did was it addressed a Court of Appeals holding that had said because an order was not listed in one of the two subsections, that it could not be appealed. The court said, no, it is finality plus the certain exceptions. And the language that the court used, and I cite it in my brief, but it's very specific. It says that subsection 1 codifies a general rule of finality, and subsection 2B and 2C provide certain exceptions to that general rule by authorizing the appeal of certain orders from dependency or neglect proceedings that are not otherwise considered final. So in that sense, the court did say, yes, it is bigger than people think if you're construing it that subsections B and C are limiting finality. Final orders are always appealable. As noted by the guardian ad litem as well, the government should be stopped from being able to assert that they should not have to pay for this treatment at this point in time. By stipulating to the treatment plan, including the requirement that it pay for the treatment, the government, which was the same party or in privity, in the same proceedings, took a position. And in that stipulation, they said that they would pay. In return, my client took a position that he would both undertake the treatment and he agreed to vacate the adjudication hearing. So both of those are benefits that the government obtained through this stipulation.
You mentioned in privity, and I confess to being confused a bit by the relationship, if any, between the people and the department here. Can you shed any light on that?
So, Your Honor, I believe that in this instance, in this particular case, here, the people took a position when they filed the stipulation. I believe that the government would have been on board with that, but I am limited to the record that we have.
When you say the government, you mean the department?
Yes, the department.
Okay. And so you're saying that they took a position, and by taking that position, you believe that, I guess they were acting as the department's agent, so they could...
Yes, Your Honor, because it is the people who have filed this case. It is the people who are acting on behalf of the government or of the department here. And so in this case, or in this instance, I would say that the people at the very least are bound by their previous assertion, and the people are the ones that are appealing now. They should not be able to take a contrary position at this point in time because they received a benefit from their previous position.
But counsel, just chronologically and procedurally, they'd already been ordered to provide the services.
Yes.
And so they're subject to a court order. They're stuck unless we say otherwise. And so to move the case forward, can't they just do that, stipulate, okay, this is how this is going to proceed, while kind of reserving the right to challenge that particular order.
I think that the order itself is really important here because that order was not an order that, okay, you have to pay. The order was you have to make a decision. Are you going to pay or are you going to remove it from the treatment plan? And the government made that decision when they made that stipulation. They said, okay, we agree moving forward, we're going to pay for it. They could have agreed to take it out entirely. And that goes to the final point, Your Honors. The fact that the lower court did not err because it found after that hearing that the treatment for my client was unavailable. And it gave the government a choice. It did not directly order the government to pay anything. It said either pay or remove it. At that hearing on February 27, 2018, there was testimony from my client's partner. She testified that they were barely getting by and that there were times when they were only able to make their ends meet because they got gifts from her parents. There was testimony by the therapist who said that the therapy itself would cost a minimum of $90 a week. And she stated that they were already delaying payment or delaying treatment because of the payment issues.
Counsel, I'm sorry to interrupt, but I see that there's someone else at council table. Are you splitting your time?
Apologies if I didn't make that clear, Your Honor. No, I will be doing the entire of the appellee's
Sorry
argument.
to interrupt. Go ahead.
I apologize, Your Honor. After taking that testimony and after hearing that, the lower court stated that based on the uncontroverted testimony and evidence before it, it was clear that my client could not pay for this treatment, and it was therefore unavailable to him. And the court stated that if the treatment was unavailable, then the government had to either make the treatment available or remove it so that my client would have a chance at success and be able to move forward with a treatment plan. This finding is supported by the record and is not clearly erroneous. The lower court's determination here is supported, and this court should respect that. Overall, Your Honors, the order that's on appeal here today is not a final appealable order. And even if it is, the lower court's findings are supported by the record. And if there are no further questions, I'll rest the case.
Thank you, counsel.
Thank you, Your Honor.
Rebuttal? You have about 3.5 minutes.
Your Honors, to the extent that there's argument in briefing and today in oral arguments that there's been some deception or some use of procedural matters to avoid cooperation with the trial court's order that the DHS pay for this treatment, that's baseless. There's nothing in the record that supports that, and I ask the court to disregard those arguments. To the point that this may essentially create more appeals, this is an evolving area of law. It's growing. It's slowing down for various reasons. When OCR was founded, when the Office of Parents Counsel was founded, that slowed things down. More appeals may happen. What also may happen is there may be procedurally consolidation at the appellate level. So there may be an appeal of one issue, and then another issue may get raised, and that could get appealed, and those could be consolidated at the appellate level. And now, with having dedicated appellate attorneys for parents and guardian ad litems, that actually would smooth things out. And it might not have the burden that the court fears. Regardless, if an order is a final appealable order determining the rights of people at the moment, then it should be appealable regardless of the amount of logjam it creates long term.
Counsel, you alluded as well in your opening argument to that this is a final order, this dispositional order is final, not necessarily because the statute says so, but just because it is. And I'm wondering why that same logic wouldn't apply to any order in a civil case on discovery, because it requires the parties to do something. I mean, it's final for the moment, as you put it.
a discovery order, motion in limine in a criminal case, those matters are pertinent to the procedure of the matter, not to the rights of the parties about the substance of the case. And that's the distinction I urge the court to draw. That there will be orders in DNN cases, there will be discovery orders that won't be final appealable orders because there'll be discovery orders before an adjudication trial. And you have to have the adjudication trial. There's, as the guardian ad litem raised in their brief, there could be an interlocutory appeal of that under certain circumstances. But I think there is a distinction between those types of orders and the order that affects, this is your custodian child, you'll live with them for the time being, for the foreseeable future. That is a final order. It doesn't matter about procedure. To address counsel's point, and the court raised this about the order from the trial court, and there was an order that the DHS was going to have to pay for this treatment. And then there was essentially dicta saying, so pick. If you think this is best, you got to include it and pay for it, or not. That is essentially ultimatum jurisprudence. That's an untenable form of law for Colorado courts. There can't be trial judges saying, you get to do this or you get to do that, but pick. That's not fair to the parties. It's not fair to the child in this case because it put the county in a position of being stuck, not between a rock and a hard place, but because between the court's order and a statute. The statute that defines an appropriate treatment plan, 19-1-103, subsection 10. And making recommendations for an appropriate treatment plan has to fit the definition of that, regardless of what ultimatum the judge has given them.
Counsel, your time is up.
Thank you, Your Honor. Your Honor, may I say one more thing? Thank you for accommodating us today.
I was going to
appreciate
say
that.
to counsel, thank you for your arguments, which we always say, but also thank you for coming down here today, and I wish you safe travels back. The case will stand submitted. We'll issue an opinion in due course. We'll be in recess, and the bailiff may so announce.
All right. The court will be in recess, subject to call.